We now officially have action from the Supreme Court on the so-called travel ban by the president. So here's what we know. They've granted cert in this case. That means they will actually hear the case itself. But that's not going to happen until the fall term in October. So that is big news. But in the meantime, what happens? We are told that they are going to lift part of the bans on those that would have been covered by the ban. So we are waiting through that. In the meantime, let's bring in Judge Andrew Napolitano as we are all feverishly piecing through what we know so far. Judge, your reaction?
Well, the reason we're chuckling is because we have summaries of what the Supreme Court ruled, since apparently some people have seen the ruling, but we haven't. So going on the basis of the summaries, we can conclude the following. This is a substantial political victory for the president, one that he actually predicted he would receive. So the Supreme Court will hear the Justice Department's appeal of the Ninth Circuit Court of Appeals, which upheld the stay on the ban, and it will hear the Fourth Circuit's the appeal from the Fourth Circuit, which did the same thing. But in the interim, between today and when the Supreme Court rules, the president's travel ban will stay in effect. And all court rulings that have interfered with that travel ban are null and void as of today, with the following exception. If an immigrant from any one of the 6 countries articulated by the president in the travel ban has a relation, a blood or legal relation in the United States of America, they will not be subject to the travel ban. All other persons from those 6 countries will be subject to the travel ban. That's actually a little bit of a nuance. It's sort of something we didn't expect, and carves out an exception in the travel ban that the president himself didn't put in there. Additionally, when the court hears oral argument on this in October, it will also hear oral argument on the ability of the president of the United States and him alone to establish immigration policy as part of foreign policy for the United States government.
Yeah, we've got a little bit more, Judge, so I can read you from what we're hearing now. Again, as you said, in practical terms, parts of the ban may not be enforced against foreign nationals who have a credible claim of a bona fide relationship with a person or entity in the U.S. They say the facts of these cases illustrate the sort of relationship that qualifies. For individuals, a close familial relationship is required. A foreign national who wishes to enter the U.S. to live with or visit a family member clearly has such a relationship. So they have to be formal, documented, and formed in the ordinary course of life, essentially. Those are the kinds of relationships that we're talking about, Judge. Does that make sense to you?
Yes, it does. But the Supreme Court will be criticized, I think, for redrafting a portion of the travel ban, but it will also be by the Trump people, but it will in large measure be lauded by the Trump people for having underscored, not in a direct way, but in a practical way, the ability of the president of the United States to establish foreign policy and to use immigration policy as part of that foreign policy. Remember, this is not a ruling on the substance. President Trump was right. President Trump was wrong. But we know that at least 5 justices of the court, we don't know which 5, we could probably guess, we know that at least 5 justices of the Supreme Court voted to keep President Trump's travel ban in place for the most part until they can formally review it in October. The exception is one that they crafted, which you just summarized, Shannon, for human beings in the 6 countries who have blood or legal relationships with human beings in the U.S. They are not subject to the travel ban. They're still subject to the ordinary requirements of immigration. Doesn't mean they automatically get here. It just means that there's no absolute and total bar as to those folks.
It's interesting, Judge, because they add on to the family relationships and go on to say this can also be relationships with entities. And they give examples because, you know, in some of these cases, they were brought about by universities who said students couldn't get to them. So they go on to say this relationship will also count. Students from the designated countries who have been admitted to the University of Hawaii, that was part of the case, they are considered to have a relationship with an American entity. So, too, would a worker who accepted an offer of employment from an American company or a lecturer invited to address an American audience.
Well, that is very, very interesting.
Yeah, that's beyond family.
Yes, because the plaintiffs in the Hawaii case are a professor in the Middle East authorized to lecture and hired by a university in Hawaii. So he's not a plaintiff anymore because he can now come in because of this exception that the court carved out. So even though they're going to hear this case in October, the people challenging it are going to have to go out and find new plaintiffs to challenge it because the people that they chose to challenge it fit in under the Supreme Court's created exception this morning.
So this was Libya, Somalia, Yemen, Syria, Iran, and Sudan, I believe, off the top of my head. Iraq
Yes.
was on the original list, and that country was removed.
These are the same countries that the Obama administration had identified as likely to produce terrorists, and the same countries articulated by the Trump State Department as well, as you say, Bill, with the exception of Iran.
So the White House is going to argue the U.S. Constitution gives the commander-in-chief the authority to keep the American people safe.
Yes.
And if he deems that there is not a proper vetting system in place, then you need to take that temporary pause and figure one out.
Nicely put, Bill. And the president will have a chance to hear with finality in October the nature and extent of his authority, individually, without consulting Congress, by executive order only, to use immigration policy as an instrument to further foreign policy to keep the country safe.
Okay, in the interest of national security, this was drafted in late January, I believe.
No, this is the second executive order.
Oh, second one,
so
okay.
This one came down in March.
Okay, then it was ruled on in early March, and the court will take it up in October. And when would you get a ruling from the justices after that, Judge?
Probably before Christmas, but give them at least a month, so
okay,
sometime
so
in November.
If it's a national security issue, you're giving, you're 11 months down the road from deciding this.
You are,
wow.
But you're giving the president the benefit of the doubt and the tools to keep the country safe in the interim. To that extent, Donald Trump did the right thing and should be very happy at this moment at what the Supreme Court has told him.
And just really interesting that there are no dissents from this decision, Judge. So that means that everybody's pretty much signed on to the framework as they're going to do it now, which is, allow certain portions to go forward, hear the case in the fall, and no dissents filed on that decision. So.
Well, it's fascinating. Our political colleagues will be talking about this for a couple of days. You can imagine the tweets coming from the Oval Office in a couple of minutes. But the bottom line is it's a victory for President Trump and for what he has said he would do and did, in fact, do.
Well, thank you, Judge. We're rolling along here. Judge Napolitano, Instant Analysis. Thank you, sir.